Ladies and gentlemen, fellow Nuffield scholars, it's an honour to be presenting here today. I'd just like to thank all the people behind the Nuffield Farming Scholarship Trust for all the work they've put in, the National Trust, my sponsor, the CLA for allowing me the time off to go and do the research, and lastly my wife for all the hard work she's put in as well. So turning now just to some of the basics of our current system in order to get an idea of how it compares. What is a public right-of-way? Well, it's a right for all Her Majesty's subjects at all seasons of the year, freely and at their will, to pass and repass without let or hindrance, and that's been the same for many centuries. At the moment, there's a number of categories of rights-of-way. Footpath and bridleway will be known to many, restricted byway for non-mechanically propelled vehicles, and a byway open to all traffic for all users. And they're all recorded on what's called the definitive map and statement, which is a legal record of these routes, going since 1949 and held by the county council or unitary authority for the area. The effect of the inclusion of one of these routes on that is that it's legal evidence of both the status and the position of that route. It's possible to add things to the definitive map based on either historic evidence or long use. Long use has to be qualifying, and under statute that's 20 years. It's also possible at the moment to divert public rights-of-way, but that's a long and uncertain process, and at the moment it's permanent. There's a separate statutory right of access under the Countryside and Rights-of-Way Act 2000. It includes open country, including mountain, moorland, heath and down, most registered common land, and as a result of the Marine and Coastal Access Act 2009, it includes coastal margin. Turning now to some of the problems, I wasn't able to deal with all of them, but obviously a couple of the key problems. Where you have a new claim over your land, the expense in defending that claim can be pretty high. I was speaking to a member recently who had an estimate of £60,000 for representation at a public inquiry, so not insignificant. On top of that, there's the time it takes to get to that public inquiry. At the time of writing the report, Somerset County Council had 341 claims on its open modifications register. And if you think a county council will do well to get through 3 or 4 public inquiries a year, that's quite a backlog. So that leads to uncertainty in your land. It can affect both the saleability and value of your land, depending on the claim and the area of land. And lastly, and probably most importantly for stress levels, it can really set the local community and the farmer at odds with one another, particularly with user evidence claims where you're both providing evidence that's going to be contradictory. Both sides can and often do fall out. Turning now to another aspect, because of the way rights-of-way have evolved over many centuries and the current legal framework, which is quite inflexible, you end up with a network that isn't really adapted to modern land use. And so two of the key things I picked up in my report that are exacerbated by that: dog attacks on sheep. Sheep Watch recently estimated that 15,000 sheep a year are dying from being mauled to death by sheep. And public fatalities. Between April 2000 and March 2015, 18 members of the public have been trampled to death by cattle. So another significant worry. So now looking at how we compare to other countries, the following is a table setting out the public rights-of-way that we currently provide. Wales, 33,000, and England, 190,000 kilometres. And when you boil that down to a kilometre per kilometre squared basis, Wales coming out on top at 1.59 and England at 1.46. Turning now to the countries that I visited, Ireland, Scotland, Netherlands and France in relation to public rights-of-way and liability, and America solely in relation just to the liability because they had some interesting legislation. I chose those countries in relation to population density, something that was similar to England and Wales, and also land use, particularly looking at the percentage of agricultural land in relation to the total. So there's a chart setting out the rights-of-way per kilometre squared. Scotland's not too relevant there because they've got open access across the whole of the country, but you can see that England and Wales do stand out head and shoulders above the rest in the rights-of-way they provide. So turning now to some recommendations, one of the key things I saw in other countries was an inherent flexibility in the system and an absence of this head-to-head litigation approach. So they were advocating permissive routes, permissive rights-of-way, with the permission of the landowner, obviously, and that enabled the routes to be flexible so that the landowner could help design that route so it didn't impact on modern land use. and adaptable. If land use changed or the public need changed, then it could be adapted quite easily without a long-winded legal process. The Netherlands had probably the best example here. It involved landowners, user groups and local government all coming together. Importantly, in a key stumbling block in England and Wales for permissive rights, the local government granted the landowner an indemnity against claims where people were using the right of way, and a payment was given on a per metre basis to the landowner, not enough to make anyone wealthy, but enough to make them think it was worthwhile doing. And chiefly, it was an amicable and inexpensive process. People weren't falling out over it, and people weren't spending huge sums of money on it. So I was lucky enough to go along to a farm in the Netherlands, Duke of Vandermaat's, at the opening of one of these routes. The route had wide appeal. It had parking facilities. The infrastructure was great and it was well set out. So it appealed both to families, people with limited mobility, and walkers alike. It also went through the farm business, the cafe and farm shops. They brought people into the business. So I would recommend that England and Wales look at developing a framework to encourage permissive rights of way and access opportunities. And it's not just land there, but there's also caves and water as well, which perhaps are underutilised at the moment and could be encouraged into permissive access. I think they should emulate the Dutch system, particularly looking at granting payments to landowners and a full indemnity. And lastly, the specimen agreement that the Netherlands government use, the Dutch government use, is appended to the report, a translation of it. Another area that I found interesting on my travels was, at the moment in England and Wales, when you think about recreational routes, you largely think about countryside and farmland. But there were examples of routes being developed in urban areas. France, GR 2013, you can see there a huge figure of 8 around Marseille, and Utrecht on foot. They were routes coming in from Utrecht out to the sort of rural areas outside, ending in a transport hub, and people could easily wander back on them. Arguably, the focus was on areas without recreational routes at that point, and also areas of high population density. So a lot of results for your resources. The other thing that I saw in other countries was a huge amount of flexibility inherent in their system, which we simply didn't have. And I found that really quite surprising. I tried to put something in that would emulate a little bit of that flexibility, so I suggested an amendment to the Highways Act 1980. I drafted a proposed temporary diversion. It was for a limited period, 40 days in any 90-day period, and it was only where livestock were around, because that's where the need is greatest. It provided significant safeguards to the network, including only diverting where livestock are around, only what's reasonably necessary, and also ensuring that it was a diversion, not a closure. I presented that to the All-Party Parliamentary Group on Animal Welfare at Westminster, and it was also picked up by the farming media, including Countryfile, and I was able to get my point across on Countryfile, and there's been some positive responses. So lastly, very quickly now, turning to liability. There are a number of different reasons why people might be wanting to access your land, and the duty and responsibility you'll owe to those people will vary depending on the reason they're entering. So some of the key areas of law that cover this at the moment: the Occupiers Liability Act 1957, which relates to visitors, people you invite onto your land; the 1984 Act, which relates to non-invitees, often trespassers, but it also includes people accessing access land if you own access land, people accessing coastal margin, and on both those two there's a slightly reduced level of liability and duty you owe to those people. There's a separate liability you might owe in the tort of negligence if there's an injury on your land. And lastly, there's an overarching responsibility to ensure you comply with the health and safety regulations. So all in all, it's a complex web. Just to demonstrate that, McGowan and Northern Ireland Housing Executive case law there set out that people using a public right-of-way would not be seen as visitors for the purposes of the Occupiers Liability Act 1957, and the 1984 Act specifically sets that out as well. Counterintuitively, though, if you wander off the line of the route, you become a trespasser, and the landowner owes them a higher duty of care. And at the moment, if you provide permissive rights of way, then they'd be seen as visitors, and you would owe them a much higher duty of care. So, to sum it up, I think the current system is unnecessarily complex, and speaking to people who are thinking about it, who've been approached, for instance, by the parish council to offer something, it acts as a significant disincentive to engaging with it. Government should consider looking at other countries that have already solved this problem. Ireland's Occupiers Liability Act 1995 sets out a third category on top of visitor and trespasser, which is recreational user, and largely it's acknowledged that people undertaking recreation activity can do it, but they do so at their own risk. Likewise, the recreational use statutes have been adopted throughout most states in America, and they've been incredibly effective at encouraging people to open up land for permissive access, and that's really been effective at encouraging land use, both walking, cycling, and kayaking. So in conclusion, England and Wales already have a very extensive rights of way network, but because of the evolution of it and the legal framework at the moment, it's inflexible and incredibly expensive. And I think we need to start moving away from that system, looking at encouraging a framework that develops a collaborative approach between landowners and walkers. In order to do that, you're going to need to simplify liability and reduce it where people are undertaking recreational activities. And also, it's astounding that there was not more flexibility inherent in our system, and I think we need to look at putting in something that allows for temporary diversions where there's particular types of agricultural activity. Just to sum up, the things that I found in other countries was incredibly useful. I've got a number of ideas going forward as sort of lobbying and work to do, and it's just been an incredibly useful process. Many thanks.